speak when invited to by the chair. If you wish to speak, please raise your hand and direct all communication via the chair. Please ensure that your mics are muted when you're not speaking. When speaking, please be succinct and do not exceed the allocated time frames. If referring to any written submissions, please refer to the specific page number in the agenda pack. Any new evidence can please use the chat function to alert the meeting or dial your meeting. Once the application has been considered, any remaining parties will be asked to log out of the hearing. Please do so promptly so that councillors will have the opportunity to deliberate and make a decision. Each party will be notified of the decision within 5 working days. However, if you contact the licensing service the following day, you will be given a skeleton decision. Can I start off with the first item on the agenda? Can we elect a chair, please?
Can I just Councillor Root, please?
Yeah, seconded.
Thank you very much. In that case, I'll pick up from here. And the next item is about declarations of interest. I wonder, do Councillor Garbutt or Smith have declarations of interest at all? No. Okay, I am going to, it's not really an interest, but I think it's probably in the interest of transparency. I should just put on record that I have attended a private function at this venue. So I've been there. Good. Okay. Perhaps I should go on a bit more and explain that having been there, I don't think to my knowledge that I've ever met any of the management or whatever. I was just at an event that was there. Right. Item 4 is the minutes of the previous meetings, and there are no minutes for consideration at this meeting. So now, sorry. Did somebody want to say something? No, maybe it's, I'm getting quite a lot of background noise from somewhere. I'm not sure where. Ravi,
Is that coming from you, Ravi?
thank you. I think that might be where it's coming from. Thank you. Okay, so the procedure is that we will hear from the applicant who's seeking to make the change. Then we will hear any objectors who are present. There are no responsible authorities here objecting to what's being proposed by the applicant. So I imagine that unless we have any of the members of the public who arrive, then we won't be hearing from them at all. Amanda, correct me if I'm wrong, but I would assume then that in the absence of any members of the public, what we would do as members of the committee is go on to question Mr. Dadds as the applicant about their concerns and take it from there, really. Is that correct?
Yes, that's correct, Chair. Yes, you'd basically consider the representations in written form. Maybe you could say, note for the record that members have considered the written representations, and then proceed on to your discussion phase and anything else.
Good. Okay. In that case, let's crack on and hear from Mr. Dadds, if that's all right.
Oh no, if we could just first hear the from the licensing officer who
so
presents
from the licensing
report.
officer
Yes.
Exactly.
Yes. Thank you.
Thanks.
Thank you, Chair. Thanks, Amanda. So if I could draw your attention to agenda item 6, which is the report begins at page 15 of today's agenda. Members are asked to consider an application to vary an existing premises licence, which is issued in respect of Unit 7, 224 Allsman Road. The application is a variation under Section 34 of the Licensing Act 2003 and seeks only to remove a condition which is attached to the premises licence. So that condition is number 46, which talked about an individual who is excluded from the premises, and not being able to undertake any activities related to the management of the business, etc. We received representations from 2 other persons in respect of this application. No other representations were received. Due to the content of those representations, they don't appear in the published agenda, but members have had sight of them, and the applicant has, of course, had sight of them as well. With that, that concludes my opening submission, unless any members have any questions. Thank you.
Any questions from, no questions from the members. So at this point, it's over to you, Mr. Danson.
Yes, thank you, members. Relatively straightforward ask and application. The starting position must be for me to point out the obvious, that no responsible authorities are objecting to the removal of condition 46, and the position would be that they would be duty bound to raise an objection if they felt it was undermining the licensing objective. So the police are the main source of advice on crime and disorder, licensing authority on policy, etc., and environmental health on environmental issues. So from the responsible authorities point of view, and certainly at our submission, given that you would have to have weight to the fact that they haven't raised an objection following the Principal Daniel Thwaite case, that they raise no objection, there'll be no undermining of the licensing objectives. The condition was imposed originally because there was concern raised around an alleged breach of condition that continued over a period of time. A new application, and that condition was regarding alcohol ancillary to food, which was never imposed, but was agreed to at committee stage, and there was a misunderstanding. But I'm not going to go into the history of that. However, since then and now, there's been a new premise license operating, and there is no condition about alcohol ancillary to food. The premise has been operating without any cause of concern. The premise license holder remains the same. The DPS remains the same. This condition is removed. There are family and friend connections between all the various parties. That's not taken away. And the individual mentioned has been a license holder, personal license holder, and that's not been removed. I will say this: the person who is named is a person of good character, no convictions, a personal license holder, and there's no reason why the exclusion should remain on the license. And there has been a passage of time. You know, it could be seen that there's been some form of punishment that can now be removed. We are concerned only with the promotion of the licensing objectives, nothing more, nothing less. And we say there's no undermining licensing objective by that condition being moved. The police agree with us, the licensing authority, and others. Now, can I just say, Chair, I have had some concerns about the representations made at C1 and C2. I don't know which one you're referring to as C1, C2, but hopefully you'll pick up from me which one I'm particularly concerned about. I have, in addition, and I don't know if Ms. North can clarify, I raised some points about an additional document that came in quite late and after the representations were made, whether that has now been excluded, or do I need to speak to that document?
Amanda, could you clarify?
Yes, sorry. That document did come in late today. To the best of my knowledge, it has come in after the consultation period and therefore shouldn't be considered as a relevant representation. But could Mr. Tuitt confirm whether or not the licensing service have confirmed that to the person?
That's correct. It's the late submission.
Yeah, so, Mr. Chair, just through you, Chair, if you don't mind me, sorry that I'm slightly out of sync. So that additional rep that came today is not, members don't have it before them or won't be considering it.
I don't
That's
believe that
correct.
members.
No, they
so-
won't be considering. They
not-
won't. Members will not be considering that representation. No.
Thank you very much. So the two representations, there's one that makes some serious allegations which are not true, and we are concerned about individuals being able to make such comments without any justification, any evidence, or any supporting evidence, whether it be a crime reference number, a sworn statement, or anything to support it. Now, under the Licensing Act, the statutory guidance under 182, and particularly about disclosure of personal details of making of details of people making representation, you'll find that, Chair, at paragraph 9.26 through to paragraph 9.30. And it makes it very clear that only in exceptional circumstances, persons making representation because of fear of intimidation or violence, will their name and address be withheld. Obviously, it's a decision for the licensing authority. And I say in this case, there is no justification for those details to have been withheld, but they have been. So I make no more comment than that. But would like to say is that there is no supporting evidence to justify these comments, and they're inappropriate, I would say. In addition to that, the maker of the statement is not present, and there are instances where if there is a genuine or well-founded fear, the licensing authority will normally make other arrangements. For example, asking someone from the local authority or a responsible authority to maybe speak on their behalf, or a counsellor. But none of that has been done here. Look, the reality of it is that the premises are promoting the licensing objectives. There are no issues arising of crime and disorder. The police, the licensing authority would have raised objections if it was necessary. I don't think I can really start unpicking the slanderous comments that have been made, and I don't think it will be meaningful. But if anyone wants to ask any questions, then I'll see what I can do to answer those. But we say remove the condition is appropriate. It doesn't undermine the licensing objectives. We ask that the variation be granted.
Thank you, Mr. Dadds. I think I'd just at this point make a quick comment to say that I think that given the nature of the allegations, we're comfortable with the idea of not disclosing who's made those allegations. But I think it's also fair to say that the allegations are, we're not anticipating referring to them in great detail in the course of this meeting.
Yes, and also, Chair, I think you will appreciate that you can't make a judgment on those allegations. They are merely that, allegations, and that likewise, it's unfair for my client to have to deal with those when the maker of the statement's not even present. But anyway, you will deal with it as it arises.
Okay, good. At this point then, I think it behoves me to hand over to Councillor Garbett and Smith to find out if they have any points of clarification at this point they'd like to put. Councillor Garbett.
Thank you, Chair. Yeah, I just wanted to pick up on something you were talking about in terms of food, because that wasn't in the papers that we had. So I know they were mentioned in previous hearings, but I just wondered if you could just explain a bit of what you were referring to about the food condition.
There is no food condition anymore. It's historic, but that was the original complaint many years ago, that there was an alleged breach of condition, and that's why that person was in effect excluded from management taking a role in the premises because of the alleged breach. And the reason why the condition was put there, it was actually put there by in effect, the applicant agreeing to it, when actually the police accepted that after a passage of time that it wasn't necessary, and ordinarily they didn't have to agree it because it wasn't within policy. So there really ought not to have been that condition placed on the license in the first place. So it's what I would consider a technical breach. But there was never prosecuted. The matter was resolved. The premises then received a license without that condition, and it's been trading without any issues. It's just giving you background why it was there in the first place. Yeah, I want to give background. It wasn't about dishonesty. It wasn't about violence. It wasn't anything that would be anything that would be a ban or a prohibition for life or anything like that. It's just to give you some context why the condition was there in the first place.
Thank you. Councillor Smith.
Yeah, thank you, Chair. So a couple of questions. You might have covered that already. I believe this particular condition we're talking about, 46, at that hearing was suggested by the applicant at the time, correct? The question is, why was it suggested by the applicant or by the solicitor for the applicant? That's number one, Mr. Dadd's question. Number two, in the representation in relation to the person named in condition 46, although there's no evidence, it seems that she's still very much involved and seen daily at the premises. So the question around that point is, how much is that person involved when licensing activities are taking place? And then the final question, so there's three questions there, sorry, Chair.
Well, let me just, so I don't get them in that order. So,
why was it suggested by the representative of the applicant, the condition?
yeah, I've got it now. I've written it
Yeah.
down. Yep.
And then the third one, Mr. Dadd, sorry to bombard you with a lot of questions.
That's all right.
And then you've had 13 temporary events notices in the last little period or whatever, and this probably applies to licensing as well. Have we had any complaints on any of those? Sorry, Chair, I don't want to
That's all
hog
right.
the meeting.
So the any complaints question, is that going to the licensing officer?
Yeah, I think so, yeah.
Okay. So Mr. Dadds, if you could answer the first two questions, please.
Sure. And I was struggling a bit because the connection wasn't great. So the first one, it was offered up because concern had been raised previously about the management skills of that individual. And we offered it up to give comfort, as in effect, for that period of time, and just let the things settle, as it were, and a passage of time. And there are other pieces of legislation that you can exclude someone from a premises, but typically the range is from 3 months to 2 years. But that's if someone's committed a crime or act of violence. This is none of that. So generally it's accepted that if you are going to prohibit someone, it should only be for a certain period of time in any event. It shouldn't be ongoing. So that's why it was offered. In relation to
Can I just follow up on that then? If you're saying that normally that sort of condition would be for a limited period, and you were offering the condition yourself, why didn't you offer it for a limited period of time?
Well, we wouldn't generally, we would put it on as a condition, and when that time passes, then ask for it to be removed. So as we've done.
So that's where we are now. That's what.
Yeah, in effect, yeah. And actually, we could have come sooner, but we've come where we've come. Yes. The in relation to the activities that there's no. It's very difficult because obviously you just asked the question now, but the licensing officer might be able to help David Stewart. But there's been lots of allegations of this lady being present whilst there's licensed activities, and I think we've had, I don't know, at least 20, if not more. There's been so many where we've had to download the footage, provide the footage to show it's not true. So it's been quite vexatious and quite ongoing but can assure you that during licensed activity, the person's not present. Licensing officers have been present at different times and checked. And we've had multiple requests for CCTV, different dates and times for them to check that it is what it is, so that they've been satisfied. Otherwise, I think you would be getting an objection from licensing today, Councillor Smith. In relation to TENS, I'm not aware of any. I know we've been here for TENS and there's been some hearings, but I'm not aware of any. And Environmental Health have not objected, but maybe David Chewett can amplify on that, because it wasn't something really I was looking at today. I hope that's as helpful as I.
Let's just talk to Councillor Garbutt for a moment to find out if she wanted to say something in relation to any of those points, and then I'll come back.
No, I'm happy for David.
It's a different point, is it?
Yeah.
Okay. In that case, Mr. Chewett, perhaps I can just ask you: are you?
I can't hear you now.
You've gone on to mute, Councillor.
Sorry, I did myself stupidly. Mr. Chewett, are you aware of any objections, complaints, etc., about the TENS applications that have gone through so far? Any complaints about any of the events that have happened there?
I do believe that there have been some complaints as a result of activity authorised by TENS. However, just generally, the premise is just due to maybe some of the history, the location of where it is. It's somewhere that does generate complaints. But just generally, I would say.
Okay. So in other words, well, perhaps we can expand that question then and say, have there been any, as far as you're aware, are there any complaints in the normal course of activities regarding this establishment, i.e. when they're just operating up to their normal license hours?
I would say that we have received complaints during normal operating hours, but again, I would just say that maybe some of that's linked to the history of this site and its ongoing operation.
I don't think they've been cooperated, and certainly when some complaints have been made, we've provided CCTV that's
Yes.
not shown to bear out what the complainant has said. So we've been dealing with a lot of vexatious complaints from someone living nearby, who may be one of these individuals here. We don't know because it's anonymous.
So I can confirm what Mr. Daz has just said, that there have been occasions where we've received complaints quite specific about times of these allegations, and on maybe 2 or maybe 3 occasions we've received CCTV and it didn't corroborate with the specifics of the allegation.
Okay, thank you. Councillor Garbutt.
Did you want to come in on that, Councillor Good? You look like you were going to say it. Otherwise, I can go. I'll go.
It was just a very brief clarification, David, on the number of times, because there's 13 temporary event notices. Roughly how many times have you had to kind of look at the CCTV where it's been, the evidence hasn't sort of stood up? Roughly,
Okay.
I know it's probably a difficult question to answer, but just an idea. Is it like 50% of them, or less than that?
I don't really want to just give an answer without. I'd have to check that and maybe come back to you on that. I think it'd be best if I do that.
Yeah, I think that's a good idea. Councillor Garbutt.
Yeah, so Mr. Dubs, I want to get into a bit around the passage of time comment that you made and offering comfort to residents, and just ask, because obviously you were saying that there were kind of issues with management skills, so I just wondered if there's been any training or any other kind of anything that's happened within this time rather than just the passage of time. That I know that you're saying that there's allegations made from residents, but these don't come from nowhere, and I think it would be really good to hear from you what comfort you're kind of offering now in terms of what's changed or what would change, and why you're kind of asking for this move now.
Yes, are you still there?
I think Councillor
I am
Garvey?
still here. Yeah, sorry.
Oh, you can still
Yeah,
hear.
I'm here.
Okay.
Did you get that though? Yeah.
Yeah, I think I got it. So if I don't quite get it, let me know. But there may be a misunderstanding on the point that I made. I talked about comfort to the responsible authorities, not to the residents. In relation to crime disorder, it's quite historic. I think there was only one issue arising in relation to an event that happened years ago. Typically, so we don't have any issues with crime disorder. We don't, and so that it wasn't about giving comfort to the residents, because no comfort was required, because the premises actually does operate very well, and that it was about around management of complying with conditions. So, and particularly the food condition about alcohol ancillary to food. So that's historic, and there is no issues at all with the operation day to day, people coming or going. So none at all. Of course, the premises has applied for its 10 on each occasion, and they have been granted. If there were issues arising, so Councillor Smith, if there were issues arising, you know, as the 10s go on, they wouldn't be granted the next one, or it might be you're given an opportunity. But as you go along, if you see page 16, you know, it is substantially, we're getting 10s all over September, October, November, December, January, February. So we're doing those events, and if there was an issue arising, then the Environment Health would have raised an objection. Of course, the premise license holder remains the same, the DPS remains the same. From a crime and disorder point of view, the police, under a 2.1 of the guidance, and the around about 6.37, I think it is. I'll have a quick look now. Bear with 1 minute. Might be 18. Yeah, so with the statutory guidance, at 9:15, it's the police would be making representation based on crime disorder if they had any, and likewise you would expect the licensing authority to engage if they had issues around conditions, environmental health around noise. So, and that's under 9.15 of the statutory guidance. So I think this idea around in comfort, we're already operating, promoting the licensing objectives, and we know that we have a complainant nearby who is vexatious and has made multiple complaints where that we've been able to demonstrate that they're not true.
I'm not sure that we can say that, Mr. Dadds.
I can.
No, I'm sorry, because we're not in a position to be able to review all of that. What we can say, we can't go as far as to say that those complaints were vexatious because you've proved that they're not true. What we can say is the CCTV evidence that you've provided didn't provide any evidence that they were true. That is a different thing. So I want to take away this idea of vexatious, because I think proving something is vexatious is difficult, just as indeed proving the allegations that that C1 is making is also very difficult. So I mean, let's just leave it at the fact that we don't have corroborative evidence, that you've offered what you could, which is obviously a plus mark as far as the premise is concerned, but there has been no corroborative evidence to back up those complaints.
Well, I think we
sort of going into all of the complaints. I think that, you know, that seems to be a reasonable position, because you can't have CCTV over every area of every spot of the premise the whole time. You know, I mean, that's.
Well, I think obviously I'm trying to be as helpful as I can with some of the questions that have been asked, because we're all trying to be helpful, and if we had more information we could support it. But I've been dealing with this premises for a number of years, and I can say that there's been some allegations where a certain suggestion has been made, and we've been able to show that that is not true, and it's been vexatious. There'll be some we've been showing evidence, I see, on the balanced probability.
Okay, we don't have any of that evidence in front of us at the moment, so let's just leave the word vexatious to one side and say that complaints have been made which we don't have any proof to substantiate.
Okay.
Is that all right?
Yes.
Just to take some of the heat out of this, if we could.
Well, there's only me here. I'm not going to argue against myself. I'll try.
Okay. I think we're still, strictly speaking, at the points of clarification element of the discussion before we move on to the wider discussion. I do have a point of clarification I want to seek from you, which is that you'd say that the condition was offered because of a result of some problems around complying with some of the rules around food ancillary to drink, etc. I don't really understand why this condition is relevant to that kind of problem. I wonder if I've looked through the minutes of the original meeting where this condition was imposed, and the minutes are actually a bit sparse on this particular aspect. They don't really give us a very good indication of why this particular condition was hit upon. And it seems to me a pretty extraordinary condition to say that, you know, you're going to withdraw a manager from being as part of the premises in order to ensure that the rules are abided by. How did you come across that how did you hit upon that as a condition? I'm going to ask another question, just sort of supplementary to that. It does seem to me that if you did have a lot of complaints from neighbours at the time, that might have been a condition that you were offering to try to pacify some of the neighbours who were unhappy about the particular manager concerned. So maybe you can just explain to me why condition 46 would actually work in terms of the conditions around serving alcohol ancillary to food. Why would you offer that condition?
Well, I'll do my best to answer it because I don't have the minutes, but my recollection is that firstly, this condition was not, unequivocally, was not offered to appease any resident or resident complaints. They have been minimal. Yes. So even when we attended, I think, that hearing, I don't think there were any resident objections. If there were, it was de minimis, it was small. I can't remember, but I don't believe there were, or no one attended. It might have been one or two, but it's always been very sparse, de minimis. So that condition was not, unequivocally, was not offered in relation to appeasing any residents. I've already said it. I'm just emphasising that point so it's absolutely clear. This condition, words to this effect, have been agreed as being enforceable. So it has to, you have to write it in a way that's enforceable in case law historically. So, you know, if a licensee falls out of favour, you put that condition on. So it's not unusual. Now, it's not about the condition. I've told you what the condition was that was breached, predominantly, but there was concern raised by the licensing authority about the management being able to comply with a condition and the compliance with that and having trust and confidence about compliance. So that's why, I'll take that note. That's why it was put in place. Now, so it's not unusual as a wording of a condition. It's not unusual to place it onto a license, and it was to do. Chair, I'm a solicitor. And a barrister. I can't mislead you. I wouldn't mislead you. And to my best of my knowledge, well, I did it at the time, so there's no doubt in my mind this condition, that the issue was around that condition, and that's why that was offered at the time. Nothing more. There's nothing complicated about it. Now, I've just been passed a note by the client, or a note message from the client, that since then and now, there's redone and passed the personal license course and an SIA badge course. So there's been some additional training since then and now. But as I say, no responsible authorities object.
Amanda.
Yes, Chair, I don't know if you want to find out when those courses were done and have they been, the information been submitted to the licensing authority for consideration? Thanks.
Thank you. When were they done and have they been submitted?
Well, we wouldn't submit them. I'll get the answers before hopefully the conclusion of the hearing. But in any event, regardless of that, if they don't know about it, they still haven't objected.
Okay.
Takes.
No, it just would be useful for us to have those dates. and-
Yes, I'll
and
get
what
them
we-
now. I've just asked for them.
Yeah, thank you. Which brings me, I suppose, let's just formalize this. I think we're moving into the discussion phase of the meeting now. It does bring me to another question I was going to ask, which is that in the original minutes, it's clear that the committee were not very impressed by the fact that the applicant didn't appear in person. And I guess as an observation, given that this person is seeking to have the condition removing them from the premises overturned, I'm a little surprised, given the comments previously from the committee chair, and given the nature of today's request, that the applicant isn't here. And maybe it sounds as though the applicant is in touch with you in some way or another. Could you just explain to us why the applicant isn't here?
No,
Does
it's just because remote hearings are very tricky, so or different. And during COVID, that's how we've been. If I was at the town hall, I would be with the applicant. But obviously, I normally have one device which is here on my screen, on another screen, through WhatsApp, and my assistant is sitting opposite with the email communication back, so there's no interruption. And I represent them on their behalf, so I speak for them. And I think it's relatively straightforward as a request. In fact, I thought this would probably be done by now because there's no responsible authorities. The issue is fairly straightforward.
True. It's a simple request, that's for sure. I think probably the fact that the objectors are not here in person sometimes may even make things last a bit longer, because we do, given the nature of the objections which are strongly expressed.
Yes, but no different to the point that I expressed about vexatious, that there's no evidence of it.
There is no evidence, I agree, and but nevertheless, they're clearly deeply felt.
Yeah, I
so-
feel deeply. I was deeply feeling and vexatious. The point is, I want you to be fair. I know you are fair, but I don't want you treating that with greater weight than the representations the way I have. If you're, it's got to be equal and fair. I say they're vexatious, but ultimately, to take the heat out of it, there's no evidence. So I'm happy to accept that.
Okay. I have another question, but I'm going to let Councillor Garbutt and Councillor Smith go first before my other question, just to move things along. So, Councillor Garbutt.
Thanks, Chair. Kind of in the spirit of the comments that were just being made, I wondered if you could just talk a bit about how the premises kind of supports the kind of cohesion and works with residents in the area. Just if you've got any channels of working with them, or what you do to kind of, support residents or work with them to kind of minimise impact of the venue on the local area, if you've got any channels of speaking to residents or anything.
Well, we did have a condition before that said that we would have a regular meeting of councillors. Oops, sorry, hang on a minute. One second, please, councillors. Sorry, I was having technical issues with the WhatsApp. So, in relation to the the Keystone coming on the.
You're on mute at the moment, Mr. Dance. I'm not sure if you're aware of that.
Yeah, sorry. The WhatsApp group, for some reason, there were calls coming in and then people speaking. So I don't know why. And they're trying to give me dates, but that's fine. But that's no good whilst I'm speaking to you, because otherwise it cuts across. So they just wanted to give me the dates, and I'll come back to that point in a second. So the SIA badge was February 2020, personal license course 2022, October 2022. Sorry about that. So coming back to the point of, there was a condition about discourse with councillors, but I actually think they wanted that removed. I can't remember, David, whether that got removed, but they didn't want to have that commitment of regular. But we have given out letters to neighbours. The neighbours immediately upstairs, we put soundproofing in, and that was resolved. And I think we were working with environmental health to test noise, and that was done, I think, a year or two ago. So we do work with our immediate neighbours. Obviously, we do have a couple that we can't work with, but likewise, we are a venue that's typically, we have some private events. The councillor chair, you've been there. It is what it is, and we try to get along with our neighbours, those that we can. So why wouldn't we? And as I say, generally there are very few neighbours interjecting or commenting on applications we've made historically.
I wonder, Amanda, correct me if I can't do this, but I'm inclined to ask Mr. Tuitt about the condition regarding meeting councillors, and if that has been taken away, and if so, why?
Yes, I don't think there's an issue why you can't ask, and whether or not it's something that they would consider.
Okay, so Mr. Tuitt, that's my question to you.
My recollection of that condition was that it was problematic in the past. It just led to an incident where there were some concerns about. So when the license was varied and went to a hearing in February of this year, with our licensing authority hat on, we asked for that condition not to be attached again.
Sorry, are you able to be any more specific than that? Was there confusion, or what was it?
No, there was, I think in February or March of last year, 2022, there were some concerns following an incident, I believe, at Shoreditch Library, where a councillor was approached, and following that, we sought to remove that condition from the license at the time. And then when the license was sought, when a variation to that license was sought, we asked for that condition not to be attached again. When I say that condition, that requirement for the licensee or management to meet with local residents or
sorry to
councillors.
push, but was that a safeguarding issue with regard to the councillor?
I believe so, yes.
Okay.
Yeah, and I don't know anything about that, so I haven't been shared with that. But there are normally in a ward 3 councillors. I was told that the councillor didn't want to be have to have that as a commitment every quarter, and didn't want to be doing it every quarter. So I don't have anything different to that.
No, I don't think that's the case, Chair. I think basically my understanding is that it was removed, as Mr. Tuitt has said, due to health and safety issues and safeguarding issues which arose, which made it difficult to actually comply with that requirement, and also it made it difficult for the premises to then comply with the condition, which was difficult for them.
But it wasn't because of us though, it wasn't the premise license holder that was causing the health and safety issues, was it?
Well, there was an incident that took place which led to the removal of that condition.
Yeah, but I'm saying I have no information about this at all, and it's a very serious allegation. I mean, I can't believe that this is being said now at a hearing. I've never heard about it before. Are you saying that the premise license holder has been involved in an incident with a local councillor that raised health and safety?
N-
I don't, not the premises license holder, no.
yeah, I was just going to say it's not the premises license holder. Yeah.
Yeah, and Mrs. Hande Seskin, and it's not her either.
No, no.
No. So this is nothing to do with Mrs. Eskin. There are many other ward councillors, not just one. So my understanding is completely different to yours. But that's why I made the proposition that it was asked to be removed. Well, we've not been told why it's been removed. And if we go on this basis, I'm going to need a short adjournment to take my instructions, because I'm being sort of not ambushed, but this is new information to me that I don't have. But it doesn't relate to Mrs. Seskin, and it doesn't relate to the premise license holder.
Yes, Chair, I think may as well be clear as to whether or not you are considering a new condition for this or not, or whether or not you're just going to put that information aside.
Well, I think I'm trying to understand why the condition was withdrawn. Now, if the condition was withdrawn because of safeguarding or health and safety concerns around the councillors meeting on a quarterly basis, then that is something that we as committee members have every right to ask about and find out about, it seems to me. Just as indeed Mr. Dadds has every right to find out about it too. I don't know if Mr. Dadds would like to have a short adjournment so that he can speak with his client. I mean, equally, it does seem to me, Mr. Dadds, that since the client is clearly listening to this on WhatsApp, that they could join the meeting, which seems a little bit bizarre that they're watching but not actually taking part.
Well, they are taking part through me. And the point is that if they're on screen, I can't take instructions. And I've already raised it with the local authority that the remote hearings are unlawful, and it's currently being dealt with at the High Court at the moment. So I can't really get into that. This is the whole point, that these remote hearings, as they are, don't allow for me to have a private conversation with the client and to have a discussion with you. But look, I'm happy for a moment if maybe Mr. Chewett or Amanda can call me and tell me a bit more details, because I don't have enough, and for me to speak to the premise license holder. But as I say, answering Councillor Garbett's question, is that we do engage with our neighbours. We have put sound attenuation. We were asked that condition to remove. This condition relating to Mrs. Hande Seskin, there's no complaint about her. There is no complaint about the premise license holder regarding this councillor. None complaint at all. And today we are dealing with only that condition where that no one has objected, the licensing authority or the police. So I don't know where this is going, because I don't think it's relevant to what we're asking to vary.
Well, if I were to spell out from my perspective why it may be relevant,
Yes, thank you.
it's simply because if a condition has been ceased because of a safeguarding issue with regard to the licensing of this premise, then it seems to be relevant to the hearing. I can see that Councillor Garbett and Councillor Smith want to pop in as well, so let's hear from them.
Can I just come back on this one quickly, just because it relates to the original question. I guess my interest in this is because, although I know we're saying that there's some alleged issues within the other person's representations, but as a councillor and as our representation, and listening to resident voice, the way that you work with residents and the local representatives of residents, I think is important. So yeah, I was interested just to hear how you do or plan to work with kind of councillors or residents. But you can come back on that if you want, but it wasn't quite a question, I guess.
And Councillor Smith?
Yeah, thank you, Chair. I'm just thinking about this adjournment, Chair. If Mr. Dadds thinks it is important to have an adjournment, then maybe we ought to consider that. I suppose I'm just saying we want to just get through this one before I move on to my questions, maybe. So we'll just make a decision around around that if you want.
I mean, I would need more information because at the moment I've got, I don't know whether there was a crime reference. I don't know if it's been proven. It was an allegation where, all that stuff I don't know about, and I need to make sure the premise license holder can respond. So, but this is not, as I say, this is not. I don't think this is relevant to this particular application because I've asked the relevant question. Does it revolve around the premise license holder? No. Does it revolve around Mrs. Seskin? No. And that's what the application is. And there are no police objection. And if it was a concern, the licensing authority would also raise a concern. So I don't know whether we're going down a rabbit hole where we shouldn't be going down. And I don't want to be rude about it. I'm happy to accommodate, but I wonder whether we're going down a rabbit hole we don't need to go down.
Okay.
Maybe you can adjourn, discuss it amongst yourselves and see if you want me to go down that path.
Mr. Smith. Sorry, Councillor Smith.
Sorry.
Yeah, I mean, I take those points. I mean, Chair, okay, so we shift it on a little bit then. Are you happy about that, or do you want to have an adjournment? What do you want to do?
I'm not sure that we're going to get very far if we do have an adjournment, because I'm not sure that Mr. Dadds is going to learn very much from his client, who may or may not know anything about this. So I think probably we do need to move along.
Okay, thank you.
No?
Yeah, the way that I'm kind of seeing all of this really is that we're trying to work out sort of the good character, as is mentioned on page 20 of the submission, of this particular person in question. And are they capable of sort of running a well-managed venue which is inclusive and safe for everybody and keeping the residents happy at the same time? So that's what we're trying to do, and we are looking at the objectives, Mr. Dadds. The public safety objective, we're looking particularly to that. You have to remember, Mr. Dadds, that this venue is currently under investigation with the planning department about the stop notice and the garden issues. So there's something, there's something going on there. So my two questions really relate to the person in question in regards to condition 46. How much is this person involved in the business, if at all, under this condition? Do they have any say in choosing the current DPS? Has the current DPS brought any levels of, has the licensing authority had anything to say about the DPS in a negative way or not? That's to David. And then if this person in question on condition 46 is allowed in the venue, if we take this condition out and they're allowed around the venue and it's all back to normal, what kind of involvement will that entail for this particular person? What will they be doing in and around that venue? How much will they be involved? Bearing in mind that the condition says shall not undertake any activities related to the management of the business. So if we withdraw this condition, are they going to be back in and totally involved in the management of the business? And what are they going to be doing?
Mr.
Sorry,
Dadds?
it's another 3 questions. Sorry about that.
Yes, I think that's really good that you ask, Councillor, because it means I can address it, at least hopefully what you're thinking. Firstly, this is not an application. This is not, as you've put it out, that you've got to look at the good character of this person or whether they can run the premises. We are not asking them to run the premises. We're asking that they can come onto premises. The premise license holder remains the same, and the DPS remains the same. If we change the DPS, we have to make an application. People could object. So that might be a step too far. So I'm not asking you for that. We're asking to remove that condition. The next thing is, I don't know how you should know about the stop notice, because that representation, I got told, was withdrawn today. So, but the thing is, the stop notice is different on planning. It's not to do with this license. And I think those are two separate things. The objections that you've got in front of you, as I say, I've commented on those. But what's really important is there's a case called Daniel Thwaite, and it says you should place great weight on the fact that the police don't object, and the environment, health don't object, and the licensing don't object. The bit about public safety, I'm not being rude, but that's a misunderstanding of what public safety means as a licensing objective. Public safety is only an objective relating to the physical building, or trip hazard, slip, the construction of the building. So public safety is not about the management of the premises. That might come under crime disorder, public nuisance, but it's not to do with public safety. But in any event, this individual, I've said it already, but I'll repeat it, is a person of good character. So they don't have any convictions. They've not been prosecuted. There's no prosecutions. They hold a personal license. They've done their retraining for the personal license, and also hold a security industry authority license to be in effect a registered door supervisor. So they are holding qualifications that are appropriate. Remember, this all arises around what I said earlier on about the continual breach of a condition, historically, alcohol ancillary to food, which they imposed on themselves, not imposed on others, and which has been removed since. That is it. It's as simple as that. So I think did I cover all your questions, Councillor Smith? Because I'm conscious I want to try to help.
Councillor Smith.
Yeah, thank you, Mr. Daz. The reason why I mentioned public safety, I'll just read it out to you. Whether the necessary and satisfactory risk assessments have been undertaken, the management procedures put in place, and the relevant certification produced to demonstrate that the public will be kept safe both within and in close proximity to the premises. Now, a lot of those allegations that we can't mention seem to have taken place in and around the venue and outside of the venue. So that's where I'm coming from in regards to public safety.
Yeah, no, public safety is only about the guidance is very clear that the public safety is about the physical building. So the risk assessments around fire safety, health and safety, it's to do with
No, it's not, Mr. Daz. I'm afraid it's not. It says it clearly that the public will be kept safe both within and in close proximity to the premises. That's what it says.
To the physical building, and people are having, say, ingress and egress, things like that. It's not to do with individuals, so it's to do with that. I don't want to get into a legal discussion with you about that, but the licensing objective is about the physical building and the physical constraints around the building and people coming to and from the building, doing it in a safe way using that building.
Did you answer the question? I can't remember now. Did you answer the question about what sort of involvement is this person going to have in the management of this?
They're not going to have any involvement in management. So they're going to be they're going to be able to work there, but they're not going to be a DPS. The DPS is the day-to-day control management of the premises.
Yeah. So why do they want to be on the premises then?
Because they want to become back involved insofar as they can work if they need to, and they can help out when they need to. It is a business that they have connections with, so far as its family members and friends that run it. And she has the premises around. They have the premises of her husband has the premise around the corner. They have another premise around the corner. So it will just help if she is not excluded from this building and can go into that building.
Because in the submissions, sorry, Jerry, I'll just carry on for 1 second. In the submissions, the July submission, quote, she is still very much involved in seeing daily at the premises. I've mentioned that already, though it feels a bit safer when she is not given full permission to roam the premises.
Who said that?
The 18th of July.
What papers? What page number is that, please?
It's the C1 submission.
Oh, C1. Sorry. This is an individual that the residents would not have had any connection or any. This lady across the road has only ever had one interaction with this. With
person. If you see my point of view. In the previous licensing subcommittee, where you offered up this condition for this person to be excluded, you didn't do that for no reason. You did that for a reason.
Yes.
So you can see from our point of view as subcommittee members, we're trying to understand, and the evidence is sort of not clear, really. I mean, concrete evidence in terms of police haven't produced a crime report about any of this stuff or whatever. But there's obviously something going on, right? There is obviously something going on. You excluded this person yourself by offering up the condition in the first place, you know. So we need to be sure that this person is of good character, as you say, and obviously, you know, you're going to give it the benefit of the doubt. At the moment, really, you know, it's 50-50 really for me at the moment, frankly, you know.
Well, let me see if I can persuade you, because you're normally very open-minded and you allow me to be heard. So look, I think this is some big conspiracy, perhaps, that you think that there's going on. There is not. Let me answer the first point, is that the lady across the road, or the resident across the road, has only ever had one interaction with Hande Zeskin. In a sense of day-to-day operation, there's been no question at all about her conduct, her manner, violence, disorder, poor drunkenness, any issue regarding her person, other than, and it's simple, I've said it already, I'm not going to go over it again, because it is what it is. That condition was offered up because the police and the licence authority at the time lost confidence in whether she would have the ability to withstand the conditions, nothing more. And the main salient condition that was complained about is alcohol was being sold, alleged alcohol was being sold, not ancillary to food. So that is it. There's nothing else. So I'm telling you, that is it, right? So there's no other conspiracy theories. There's no issues with this lady with interaction with the members of the public, no complaint whatsoever. Now, you say, well, we have to go on the evidence we got, no police reports. Well, that is actually what Daniel Thwaite says, is that you should be weighing very greatly in your decision making. If there was a concern, the police would be here. If there was a concern, the licensing authority would be here. So take that as it is. So I think from that point of view, and talking about character, this lady holds a personal license, holds an SIA license, is a person of good character and no convictions. You've heard no evidence contrary to that. You have to accept that. Not 50-50. It's on, you know, you have to accept, in effect, unless you've got evidence contrary to that, that's the submission made. I wouldn't be saying to you now that this is a person of good character if the person wasn't of good character.
Councillor Smith, do you want to come back on that at all?
Yeah, Mr. Dance, I just don't want to see this back again. You know, this venue. I really don't, because it's been coming back again and again and again and again, and you're getting complaints all the time. You know, so if you're right, if this person's not causing a problem, then you won't be back again in relation to this person.
Yes, that's right.
Yeah.
I mean,
you know, so the proof of the pudding will be in whether it comes back or not.
Well, I think actually, Councillor Smith, look, I think you're right. The proof of the pudding is that. However, I don't want to get into, he said, you know, backwards and forwards with you, because that wouldn't be right. And I've said to you, I've always treated you with respect, and I do respect you as being a forthright, a good counsellor. I have no problem with that. But look, please, with regards to this venue coming before you problems, that there hasn't. There's been one review which was dealt with historically because of one issue arising historically. There's been no other review. The reason it's been before you a couple of times is because a neighbour nearby has complained. Oh, well, there was a neighbour, if you remember, complained about noise, and we did extra soundproofing. We adjusted the noise limiter and we dealt with that. That was noise. But on crime and disorder, there are no complaints. I don't want you going away thinking, or the other members thinking somehow this is a terrible venue, because it is not. Yeah. And I really want to emphasise that.
Okay, Mr. Dance, I'm just going to sort of
Thank you, Councillor
draw
Smith.
this to a bit of a close on this line of things. I think crime and disorder issue is, you know, there's nothing from the responsible authorities, but there are some allegations which have been made, which we're not in a position to explore one way or the other in this particular setting. So, you know, crime and disorder is an issue with regard to this venue because it's been raised in the documentation. But as I say, we're not in a position to be able to explore one way or the other you know, can't investigate that or even interrogate it at this point because the people who've made those submissions aren't here. So I think we probably need to move on.
Can I just say this so that you know, Chair, and for all members, and Amanda North can advise you later, but at 2.7 under public safety, it says the licence holder has the responsibility to ensure the safety of those the premises, part of their duty. This concern of the safety of people using the relevant premises rather than public health, which is addressed by other legislation. Physical safety includes prevention of accidents, injuries, and the immediate harms that can result from alcohol consumption, as with unconsciousness or alcohol poisoning. Conditions relating to public safety also relate to promoting crime, disorder, or objective as noted. So I just want to make it absolutely clear that the guidance is telling us about the physical safety of to prevent accidents and injuries, and normally the public safety about physical. Oh, Councillor Smith is not there. Sorry.
No, he is.
There he is.
He's also looking
He's
through
kind of good.
as well.
2.7. Anyway, thank you.
Okay. Councillor Garbett.
Thank you, Chair. I just wondered if we could give the applicant the opportunity to just talk through what processes are in place to manage complaints, just briefly, and obviously just stress to any residents that they must raise any of their concerns that relate to crime and disorder with the police if it's appropriate. I know it's more of a statement, but just because I think that seems to be what we've kind of got into or going round. But I just wanted to give Mr. Dudds an opportunity just to say what the premises does do in response to complaints it receives.
We have a telephone number displayed. We typically are receiving a complaint from a person across the road, and they have a camera faced completely against our premises, so they are recording all the time our premises. So, and if they've got any complaints, they complain to the licensing authority or to the police, and then we deal with that because we have cameras on our premises. So, but in sense of crime disorder or any complaints about people on the premises, we don't have any, or I haven't got any that's material. So it's actually well run. I mean, this
So
is.
are you saying that that the complaints that Mr. Tuitt was talking about earlier on haven't actually come to you? They've just gone straight to him. Is that the point? That because to me, one of the issues, I suppose, is that clearly there are some neighbours who live close to this premise who do not want this lady to be managing or involved in the premise as again. So my question really is, how are you going to reach out to those people and to try to pacify them that everything will be okay? Because, you know, it's one thing to say that, I mean, in a sense, to me, it's a breakdown of community relations when complainants don't complain directly to the premises. Ideally, you know, they should be complaining to the premises first. If they don't get any satisfaction, that's when they go to the council. It's a breakdown of local relationships when local people feel that they have to go straight to the council. So my question really is about how, given the background that we've clearly established on this case, are you planning to try to build those bridges at this point?
Well, I think, look, it's a fair point, Councillor, you make, that ordinarily, in the normal course of business, if you have a matter arising with a pub or a neighbour and you live next door to a pub or a licensed premises, you have discourse. I live next to one, and if I've got an issue, I will speak to my neighbour, and that gets resolved. We've got a problem with one of our neighbours as being vexatious. I know I keep on mentioning it. You don't want me to say the term, but you know, even your own council officers have looked at what it is. Now, look, I don't know what the resolution is. Is that, you know, we offered up before that we would meet the councillors. I offered up before that we got a telephone number there. I mean, if the two complaints C1 and C2 want to have my details, I'm quite happy to receive them into this office. We can give an email address for that, and you know, we can then try to liaise if need be. But the reality of it is that, you know, if someone, there was someone originally in the studios looking to sell their property, and they didn't. And what happened originally was the embankment area was used by the people in the studios all the time. When it was taken back by the landlord, they raised complaints about they couldn't use the bank anymore. So there was one person in the studios that continued to complain thereafter. Nothing we could do about that. The lady across the road doesn't want the premises to be open, and since day one has voiced that concern. There's nothing really we can do about that either. All we can do is address the concerns if they raise them, look to see whether there is actually anything in it, because clearly if there's some concern, we will address it. I think Councillor Smith has spoken to the DPS before, and we even, if I recall, we even offered mediation, or said, look, we will do mediation with the local police. I'm offering now. I would be quite happy to head up mediation on behalf of the premise license holder with the licensing authority and the neighbours. Of course, we'd like to break the deadlock. So the thing is, I've been here. Councillor Smith knows what I'm like. I'd rather people work together and work against each other. I encourage that every time. I can come on here and argue all day long. As I said to you earlier on, I'm the only one here. I could argue with myself. But the point is, I do try to avoid that. We do try to avoid that. And we try to mediate, compromise, and try to get success. So for everyone, because ultimately I go away and go home, you go away and go home, they're living with each other. So they've got to get on. But we have to also recognise that you won't always please everyone.
Okay.
But I'm offering mediation.
No, that's true. And so if we were minded to accept this amendment or to withdraw this condition from the license, but to include something along the lines of potential mediation between neighbours and the premises license holder, that's not something that you would object to.
No, and what we could do, so that this, and I've done it before. The thing is, I give an undertaking not to disclose the identity, so I can deal with it, as a solicitor and a barrister, and with David Jewett, for example, and we can meet at the town hall and we can try to see if we can find some resolution. Because obviously, I wouldn't, if I give an undertaking, that it wouldn't be disclosed. So the reality of it is, we might be able to find somewhere, or a local councillor could come involved. Now, I'm happy to try to help. If I can.
Okay. Councillor Smith?
Yeah, I'm just wondering if it might be worth thinking about involving the Civil Mediation Council, because they offer mediation services, or is that just going a bit too far? Mr. Dadds?
I don't know the service, sir, but councillor. So, but I think that is that the same. Is that the same with the ACAS?
Yeah, I think it's like a kind of independent body that come in and basically sort of, just mediate between parties to try and find a peaceful resolution. You can look them up, you can Google them. I'm just wondering if
is it ACAS?
I don't think it is. It's called the Civil Mediation Council.
Certainly would have a look at it. I think one's got to be careful about specifically naming a group or an organisation in a condition, but I'm certainly with the principle of trying to get mediation, even by using a third party or the local authority to help. Yeah. David Jewett may not want to be volunteered up, but I'm quite happy to do that if need be.
So we could, if we were to describe it as third party specialists, you'd be happy with that?
Yes, obviously for mediation it requires both parties to participate.
Absolutely. No. It can't happen with only one side. No, I agree. Okay. I don't know if the other councillors have got any other points that they want to raise or not, but at this point I'm sort of minded to move towards offering Mr. Dadds the opportunity to offer his concluding remarks. Yeah?
Yes.
Good. Let's do that.
Well, I'll be brief. Look, I'm always grateful for being able to be heard. You may not always agree with me, but I'm happy that at least I get the chance to speak on behalf of the premise license holder. The removing of this condition, as I've said before, raises no objections from the responsible authorities, and I ask you to weigh that very heavily in your decision making. There's no suggestion of poor character insofar as she is a person of good character, and she holds appropriate licenses, which I've described. The reason for the exclusion was, as I have already explained, relates to, on her part, not complying with certain conditions in the past, particularly in relation to the food and alcohol ancillary, and there has been a passage of time since then and now, and that's important. There is no suggestion whatsoever that Miss Eskin had been involved in any altercation with neighbours. We don't accept that, or any dishonesty or violence or anything of that nature, and refutes any suggestion of the same. And in fact, I think she tells me that she's only had one interaction with a neighbour opposite. Other than that, there's been no interaction. So I don't know where that's all coming from. But in relation to this premises, the premise license holder remains the same. The DPS remains the same. There would have to be applications to vary that should that change. So this is a fairly straightforward ask, notwithstanding we've had quite a robust discussion. It as you say, Chair, clearly one or two neighbours are still unsatisfied, and to give them some comfort and assurance, we're quite content to enter into some mediation to understand, and it might be just through the passage of time again that they'll see no change, and that those concerns will be allayed. But if their concerns are they just don't want us there and they want us to go, then that's an objection which can't be sustained, and I won't ever be able to deal with that, nor will you. So, we can't, but we can certainly give it a try. And I want to just be clear, this premises does not and has not come before the committee in relation to review only once, not since, and that was quite specific, and that licenses have been granted, 10s have been granted, and so that this is not a premises that causes trouble, crime, disorder, or I'd say even public nuisance. And if it did, I genuinely believe that your professional officers in nuisance, police, licensing would be here and to be saying that. So, and they're not. So unless I can assist you further, those are the submissions. I do thank Councillor Smith for his robust and in these conditions and these challenges, and no disrespect is meant. So to him, and I've certainly found it a challenge, but I know that he's not disrespectful, just probing. So, and I thank you all for listening and letting me speak on these points. I can't hear you, I'm afraid.
Sorry. Councillor Smith, any points of clarity to raise at this point?
No, just to read from the website about this Civil Mediation Council. Registered charity, one of our primary purposes is to provide the public with a trusted directory of mediators across various areas, including workspace, civil and commercial, community, education, and more. It liaises with government, civil justice council, different mediation organisations, employers, other stakeholders, promote mediation as an effective means of conflict resolution. So, I think an independent mediator in this case, actually, Chair, would be really beneficial for both parties. And it would be great if everyone, I don't know if the others are watching this via YouTube or whatever, yeah, and the person mentioned in condition 46 are obviously online. It'd be great if we could come together and get an independent mediator just to kind of speak through some of these issues.
I think you're right. I think we would be looking at a third-party mediator because clearly we've got to something of an impasse. And yes, so I think if we were to include that as a condition, it probably would state something about, as you say, somebody independent from outside of the mix of the premises owners and the neighbours and indeed the council who could oversee any kind of further discussion. Sorry, Councillor Smith, did you want to say something else?
No, sorry, Chair, that was a legacy hand, sorry.
Good. Okay. I think then that we can probably wrap this up if that's all right, and we will end the meeting here because we've got no TENS applications or anything else. And you should hear, I think, tomorrow verbally, Mr. Daz, what the decision is, and that'll be written up in due course.
Super. Thank you very much.
Thank you.
Thank you, Mr. Dad.
You're welcome.
Bye-bye.
Thank you. Thank you, councillors.
Thanks, David.
Right.